I'm Carol Johnson, the Commissioner of the Department of Human Services. The Stephen Kaminos Law is designed to advance our efforts in providing quality services for adults with developmental disability. The law establishes new requirements for the Department, our Division of Developmental Disabilities, and for community providers. The law increases site visits by DHS representatives, enhances communications with guardians and families, and expands the drug testing policies currently used in the developmental centers to community provider programs. There will be greater transparency in investigations, and criminal penalties will be enforced for failure to report a potential abuse. As we work together to provide quality services here in New Jersey, each of us has an obligation to help ensure that our direct support professionals, supervisory personnel, and organizational leadership understand the vital nature of incident reporting and the necessity of reporting potential abuse, neglect, or exploitation. Thank you for your commitment to providing quality services that prioritize safety and protection from harm for individuals with developmental disabilities.
Welcome to the New Jersey Department of Human Services overview for providers on the Stephen Kaminos Law. The learning objectives for this presentation are to provide an overview of the Stephen Kaminos Law, to help you understand your responsibilities within this law, and to provide you with information for ensuring compliance. The Stephen Kaminos Law establishes new processes and requirements for facilities, providers, the Division of Developmental Disabilities, and units within the Office of Program Integrity and Accountability within the New Jersey Department of Human Services. The Stephen Kaminos Law is a New Jersey law named after Mr. Stephen Kaminos, a young man with a developmental disability who resided in a New Jersey group home. In 2007, Mr. Kaminos tragically passed away at the age of 22. The law was created to strengthen protections for adults with developmental disabilities who reside in state-operated developmental centers, community-based residential settings, who attend day programs, or who receive DHS-funded, licensed, or regulated services in the community. The law takes effect beginning on May 1st, 2018. The law establishes requirements for state-operated developmental centers, agencies serving individuals in community-based residential settings, including group homes, supervised apartments, and community care residences. This also includes providers of services for individuals with a traumatic brain injury and other types of service providers, including day programs. There are elements of the Stephen Kaminos Law which specifically apply to your facility, agency, or program. There are also elements of the law that directly apply to staff who provide care to individuals with developmental disabilities. It is important that all staff working with individuals understand and adhere to the requirements of the Stephen Kaminos Law. This presentation will help you understand your responsibilities within this law and also provide you with information for ensuring compliance. As a result of the implementation of the Stephen Kaminos Law, there are significant changes to key practice areas. These include 2 unannounced site visits every year by a DHS representative to community residential settings, a 2-hour time frame for reporting injury to guardians or family, injury verification within 48 hours by a DHS representative, strengthened requirements for reporting abuse, neglect, and exploitation, additional penalties for failing to report, and drug testing of direct care staff. Additional changes to key practice areas include expanded inclusion of guardians or family members in multiple areas, including opportunities for guardians and parents to exchange contact information, guardian observation of a DHS investigative interview of the individual the guardian represents, provision of reports and records of an investigation if the information is needed to provide care, treatment, and assessment of, or supervision to an individual, and is determined by the Division of Developmental Disabilities to be in the individual's best interest. The Department of Human Services is working to implement the provisions of the Stephen Kaminos Law and ensure key information is communicated to all stakeholders. For providers, these efforts include meeting with leaders and members of provider trade organizations and presenting information on the law, creating various informational documents, and posting this material on the department's website and social media, working with the College of Direct Supports to create a mandatory training module as part of the bundle of required training, and the inclusion of a post-test for all direct care staff. As a provider for individuals with developmental disabilities, you have a critical role and responsibility. The work you and your staff do every day is important. You and your staff support and make a difference in the lives of individuals. And as your staff perform daily tasks, you have a responsibility to oversee their work and keep the individuals you serve healthy, protected, and safe from harm. Your efforts and your decisions, and the efforts and decisions of your staff, help keep individuals safe. Understanding and following laws and policies is also critically important to providing quality care and keeping individuals healthy, safe, and protected from harm. This includes understanding and abiding by the Stephen-Komnenos Law, which is the subject of this presentation. The first element of the Stephen-Komnenos Law is the requirement for representatives from the Department of Human Services to make 2 unannounced visits annually to all individuals residing in group homes and supervised apartments. The unannounced visit is to assess if individuals residing in these settings are at risk of or being subjected to abuse, neglect, or exploitation. The Department of Human Services established a Field Safety and Services Unit within its Office of Program Integrity and Accountability, also known as OPIA, to perform this function. This unit will be operational shortly, and unannounced visits will begin in the coming months. Your role as a provider is to cooperate with the OPIA Field Safety and Services Unit staff conducting the visit. During the visit, the OPIA representative will ask to speak with the individuals alone or with a staff member present. The OPIA representative will ask to see all the rooms in the home. The OPIA representative will want to speak with the staff working in the home, and the OPIA representative may ask to see records or other documents. If issues or concerns are identified that affect the health, safety, or well-being of individuals in the home, the OPIA representative will ask that the concern or issue be taken care of immediately, and the representative may reach out to administrative staff. You may wish to consider identifying administrative staff who will take the lead in acting as a liaison to the OPIA representative and who will have the ability to remediate issues immediately if necessary. These unannounced visits are an opportunity for DHS and providers to identify potential issues and address them before they develop into incidents that impact on the health, safety, or well-being of individuals. Data identifying trends, issues, and concerns will be shared with providers, the Department's Office of Licensing, and the DDD Provider Performance and Monitoring Unit. Additionally, providers will have the responsibility to follow up on any identified issues or concerns. The DDD Provider Performance and Monitoring Unit will also work in collaboration with providers to ensure identified issues or concerns are remediated. Remember, the Field Safety and Services Unit will initiate unannounced visits in the coming months. Another element of the Stephen-Komnenos Law, effective May 1st, 2018, is the requirement that guardians of individuals be notified in person or by telephone within 2 hours of all minor, moderate, or major injuries that are required to be reported to the department. Notification to guardians includes guardians appointed privately, and also guardians appointed through the department's Bureau of Guardianship Services, also known as BGS. For staff working in community agencies or programs, this means that all injuries related to allegations or incidents of abuse, neglect, or exploitation must be reported to the individual's guardian. Notification in person or by telephone within 2 hours must also be made to an individual's guardian involving all major or moderate physical injuries, regardless of the cause or even if the cause is not known. This initial notification must be in person or by telephone. If the individual does not have a guardian, this notification must be made to a family member who asks to be notified. Unless the individual specifically states the family member should not be notified. If there is a legitimate reason why the notification was not provided within 2 hours, the notification must be provided within 8 hours. Any delay beyond 2 hours requires a written explanation to the guardian and to the department indicating the cause for the delay. Follow-up communication can be done with the guardian or family member via email or other electronic communication. For staff working in developmental centers, all reportable minor, moderate, and major incidents involving injuries are required to be reported to the individual's guardian or family member. This means that all injuries related to allegations or incidents of abuse, neglect, or exploitation must be reported to the individual's guardian or family member, and notification in person or by telephone within 2 hours must also be made to an individual's guardian or family member involving all injuries, including C-level minor injuries, such as injuries resulting from an accident, a fall, self-injurious behavior, pica ingestion, restraint-related injuries, and injuries that are related to unknown cause. This initial notification must be in person or by telephone. If the individual does not have a guardian, this notification must be made to a family member who asks to be notified, unless the individual specifically states the family member should not be notified. If there is a legitimate reason why the notification was not provided within 2 hours, the notification must be provided within 8 hours. Any delay beyond 2 hours requires written explanation to the guardian and to the department indicating the cause for the delay. Follow-up communication can be done with the guardian or family member via email or other electronic communication. Remember, this element of the law applies to state-operated developmental centers, providers of community-based residential programs, and providers of day programs. This also includes providers of services to individuals with a traumatic brain injury. If the individual does not have a guardian, this notification must be made to a family member who asks to be notified, unless the individual specifically states the family member should not be notified. If there is an extraordinary and legitimate reason why the notification was not provided within 2 hours, the notification must be provided within 8 hours. Any delay beyond 2 hours requires a written explanation within 14 days to the guardian or family member and to the critical incident management unit within the department, indicating the cause for the delay. While the initial notification must be in person or by telephone, follow-up communication with the guardian or family member may be through email or other electronic communication. The guardian or family member may indicate in writing that he or she does not wish to be notified. Reporting injuries to guardians or a family member is an important responsibility all providers have. These requirements for reporting injuries to the guardian or family member within 2 hours, and in extraordinary circumstances, no later than 8 hours, with a written explanation to the guardian or family member and to DHS within 14 days, should be included within your incident reporting policies. All other DHS and DDD incident reporting requirements should also be part of your internal policies and be followed. This includes the requirement to report all incidents timely to DDD and the requirement of all staff to immediately report incidents or suspicions of abuse, neglect, or exploitation. For DHS facilities, staff should follow their facility protocols regarding the facility staff person responsible to notify guardians and families. DHS and DDD requirements do not take the place of any additional reporting policies providers may have. However, providers may not have policies that require less than what the law, DHS, and DDD require. It is also important that staff are trained, understand, and follow all notification and incident reporting requirements. Remember that a guardian or family member may express in writing to you that he or she does not wish to be notified. A guardian or family member may also identify parameters regarding what they wish to be notified about. For example, a guardian of an individual residing in a developmental center may wish to be notified about incidents involving only a major or moderate injury. It is important that providers obtain notification preference information from all guardians or a family member and keep that information on file. The department suggests that providers develop a form for obtaining this information that a guardian or a family member reviews and signs. The information should be kept updated and accessible. Also, keep in mind that an individual that does not have a guardian may indicate he or she does not wish his or her family member to be notified. In those situations, it is important that the information also be documented and kept on file. To further comply with the law, DHS updated its incident reporting form for providers to document that an injury was reported to the guardian or to a family member within the 2-hour time frame. It is also important that providers maintain internal documentation that an injury was reported to the guardian or to a family member within the required time frame. Providers should make at least 3 documented attempts to notify a guardian or family member within the 2-hour time frame. Providers are permitted to leave a voicemail message. However, when leaving a message, do not provide specific health-related information that is protected by the Health Insurance Portability and Accountability Act, also known as HIPAA, or information that is protected by other confidentiality laws. When leaving a voicemail message, remember to provide the name of the person calling, the agency name, the date and time of the call, and a number for the guardian or family member to call back. It is important to ask that the guardian or family member call back so that the nature of the incident and injury can be explained and the guardian or family member can ask questions. Remember that a written explanation and justification to the guardian or family member and to the department's Critical Incident Management Unit is required within 14 days when the injury is not reported to the guardian or family member within 2 hours. Also, as part of its quality assurance activities, DHS and DDD will track provider compliance and follow up with providers as needed. Beginning on May 1st, 2018, the Stephen Komnenos Law also requires that a representative of the Department of Human Services verify the level of injury for all reports and incidents involving any minor, moderate, or major physical injury related to allegations or incidents of abuse, neglect, or exploitation, or any major or moderate injury regardless of the cause. Additionally, there may be other injuries that may need to be verified. This element of the law pertains to any individual who resides in a developmental center, group home, or supervised apartment, including providers for individuals with a traumatic brain injury. The department established an incident verification unit within the Office of Program Integrity and Accountability, Critical Incident Management Unit, to perform this function. The verification must be completed within 48 hours, and the individual must be seen by the OPIA representative. The individual may be seen within his or her home, a day program, or at another location. Verifications may be completed by OPIA staff during the day, in the evening, and as needed on weekends or holidays. The OPIA Incident Verification Unit representative will contact the agency to establish the current location of the individual and will provide an approximate time the OPIA Incident Verification Unit representative will arrive to verify the incident. For this element of the law, it is important that providers identify a liaison to work with the OPIA Incident Verification Unit representative and assist the representative with locating the individual. The Incident Verification Unit representative will ask the liaison to advise who should be contacted to assist in providing the location of the individual. The liaison can be the provider's unusual incident coordinator or other identified staff. Depending on the size of your agency and the number of sites your agency has, more than one liaison may need to be identified. Additionally, it is important that providers and direct care staff cooperate with the OPIA Incident Verification Unit representative. Understand that the Incident Verification Unit staff may take photographs of the individual's injury. Allow the representative access to the individual or individuals. Answer any question the representative may have. Provide assistance to the representative as needed, and provide any documents or photographs as requested. Providers should ensure that direct care staff are aware of the Incident Verification Unit and the unit's role and authority to verify the incident and injury level. DHS, DDD, and its providers have a shared responsibility to ensure the health, safety, and well-being of all individuals served. Reporting incidents timely and accurately is an important part of ensuring that individuals are healthy, safe, and protected from harm. Promptly reporting incidents also ensures a timely and appropriate response. And it is critical that incidents be reported timely to ensure compliance with the Stephen Komnenos Law. Additionally, information within reported incidents helps providers, DDD, and DHS to make important decisions that directly impact individuals. Again, reporting all incidents timely, accurately, and according to DHS and DDD policies is critical. Effective May 1st, 2018, another element within the Stephen Komnenos Law is the requirement for community-based residential providers and day program providers to request contact information from each guardian or parent for the purpose of exchanging this information with other guardians or parents of individuals residing in the same group home or supervised apartment or attending the same day program. If the guardian or parent agrees to share contact information, the provider must share this information with other guardians or parents within the same home or program to enable guardians or parents to share their experiences. The department's Office of Licensing is requiring providers to have a policy and procedure for how this element of the Stephen Komnenos Law will be implemented. And the Office of Licensing will look to ensure providers have a functional system for exchanging parent and guardian contact information. Additionally, the law requires that developmental centers schedule meetings twice a year with guardians and parents to provide an opportunity to share their experiences. The department anticipates that providers will continue to consider any special requests or preferences a guardian or parent may have regarding the contact information they provide. One guardian may choose to share only a phone number. Another guardian or parent may wish to share an email address. It is important that providers develop a policy and procedure for sharing contact information. This policy should include creating a document for a guardian or parent to indicate their permission and preference for sharing information, and the provider should keep this information accessible and at each site. The document should be shared with a guardian or parent when there is a new admission, and be shared with a parent or guardian for all existing individuals served. For providers of larger programs, such as a day program encompassing many sites or rooms, the policy and document should include information to guardians or parents on the scope of who is included in the information exchange. Again, this information should be kept updated and accessible at each site. Individuals with a developmental disability may be at risk for being abused, neglected, or exploited by the staff who care for them. In fact, national research reflects that men and women with developmental disabilities are at a significantly greater risk of abuse, neglect, exploitation, or other types of violence. When abuse, neglect, or exploitation occurs to an individual with a developmental disability, their physical and emotional health and their safety and well-being can be affected. In the beginning of this presentation, we discussed that you have a responsibility to protect the people you care for and a responsibility to keep them healthy and safe. This means you and your staff also have a responsibility to immediately report any incident or suspicion of abuse, neglect, or exploitation. You have always had the responsibility to report abuse, neglect, or exploitation. However, the Stephen Komnenos Law reinforces this requirement and sets serious penalties for failing to report. These penalties include establishing that a person failing to report is a disorderly person, which is a criminal offense. Effective May 1st, 2018, the Stephen Komnenos Law also establishes that a person who fails to report, if convicted, is subject to a $350 fine for each day the abuse, neglect, or exploitation was not reported. This provision of the law is separate from and in addition to the requirement for injuries to be reported to guardians and family members. All incidents or suspicions of abuse, neglect, or exploitation must be reported as soon as possible to the Division of Developmental Disabilities. The department and DDD maintain an allegation-based system. This means that you do not need to confirm that abuse, neglect, or exploitation actually occurred before it is reported. It also means that if an allegation is reported to a provider or to staff by anyone, it must be reported to DDD. The Division of Developmental Disabilities also has unusual incident coordinators on staff to assist providers. These staff are available to answer any questions about incidents and allegations. It is important that serious incidents or allegations be reported immediately, including those related to abuse, neglect, or exploitation, the death of an individual, serious injuries involving an individual, or other serious incidents involving individuals. DHS and DDD policies for incident reporting can be found at the website identified on this slide. This is the contact information and corresponding counties for DDD's Unusual Incident Coordinator units. Please keep this information handy and available. Additionally, Direct Care staff must complete all required College of Direct Support trainings and agency-specific trainings regarding understanding, preventing, and reporting abuse, neglect, and exploitation. This includes the new training module related to the Stephen Komnenos Law. The Stephen Komnenos Law training module emphasizes the importance of reporting incidents and allegations involving abuse, neglect, and exploitation, and includes a post-test to measure staff understanding. For existing staff, the Stephen Komnenos Law training module must be completed within 60 days of its availability through the College of Direct Supports. For new staff, the Stephen Komnenos Law training module will be added as part of the College of Direct Supports mandatory training bundle for new hires. To further ensure compliance with the law, providers need to document on the department's updated unusual incident reporting form whether staff failed to report or delayed reporting if this information is known. The department and the DDD Provider Performance and Monitoring Unit will track incidents involving staff failure to report. This information will also be identified during investigations completed by the department's Office of Investigations. Information regarding staff failing to report may also be reportable to the police. Providers should have policies and procedures that mirror the law and the department and DDD's policies for incident reporting. It is important that staff working with individuals understand their responsibilities to report incidents and suspicions of abuse, neglect, or exploitation, including what to do in situations where the health, safety, and well-being of an individual is immediately threatened. It is also important that staff understand they are responsible to intervene if they witness an individual being abused, neglected, or exploited, and the consequences if they do not report or intervene. It is also critically important that staff understand what to do if they themselves are fearful in a situation where an individual is being abused, neglected, or exploited, and that it is just as important to report information they may hear from others about an individual being abused, neglected, or exploited, even if they did not directly witness it. These elements are crucial pieces for preventing abuse, neglect, and exploitation. They are also important for protecting everyone's safety and for ensuring quality outcomes. Additionally, the Stephen Komnenos Law requires that when reporting an incident or allegation of abuse, neglect, or exploitation, specific information should be included in the report. Specifically, providers and staff should follow the department and DDD's incident reporting policies and include as much of the following information as possible: the name and address of the individual with a developmental disability, the name of the guardian or any other person involved with the individual, the name of the person who is or may be responsible for the abuse, neglect, or exploitation. If known, describe the individual. If known, say if the individual has any injuries, where those injuries are on the individual, and how severe the injuries are. If known, say if there are previous injuries, and report any other information you believe might help. Providers and staff should follow the department and DDD's incident reporting policies and report all incidents and allegations through the established reporting processes. However, the Division of Developmental Disabilities also maintains a toll-free number for other entities to call to report allegations, suspicions, or incidents involving abuse, neglect, or exploitation. That number is 1-800-832-9173. All providers and staff should know that when in doubt, always report. It is better to be safe than to be sorry, and it is the law. Effective May 1st, 2018, the Stephen Comninos Law establishes that a guardian may be present during a Department of Human Services Office of Investigations interview of the individual the guardian member represents. Guardians may also provide information to facilitate an investigation. If the individual does not have a guardian, a family member may provide information unless the individual expressly prohibits the family member from participating or providing information. The input of guardians and family members is critical to any investigation. To ensure compliance with this aspect of the Stephen Comninos Law, the department provided all its investigators and investigation supervisors with updated training to assist guardians with understanding the investigation process. Additionally, the Office of Investigations is including an insert with the initial letter it sends to guardians. The insert will explain the investigation process and help guardians better understand what to expect when participating in an investigative interview. The department's Office of Investigations routinely contacts guardians and notifies the guardian that an investigation is underway. For this provision of the Stephen Comninos Law, effective May 1st, 2018, the Office of Investigations will routinely contact the guardian and invite their participation in the interview of the individual the guardian represents. The investigator will speak with the guardian in advance of the interview and explain the investigation process to the guardian, including information about how he or she can help during the interview. The investigator will also advise providers of situations where a guardian chooses to participate in an interview of the person the guardian represents. Providers may also be asked to assist during the interview as needed, particularly in situations where supervision of the individual must be maintained. It is important that providers maintain accurate information concerning who the identified guardian is for the individual and keep this information on file. Also effective May 1st, 2018, the Stephen Comninos Law includes a provision that the guardian of an individual must be provided with a written summary of the findings of the department's investigation involving an allegation of abuse, neglect, or exploitation. The law further allows a family member to receive this information if the individual does not have a guardian. However, the individual can express that he or she does not want their family member to receive this information. The Office of Investigations routinely provides a detailed findings letter to guardians. This letter includes specific information outlined in the Stephen Comninos Law, such as the date of the incident or date the incident was reported and an incident number, the summary of the allegation or allegations, the findings for all allegations, the rationale for the finding, and a description of the incident if the finding is substantiated. If known, whether criminal charges were filed. In substantiated cases, if the perpetrator's name was or was not referred to the department's central registry. And to further comply with the Stephen Comninos Law, whether or not remedial action was taken. Providers also receive a detailed findings letter at the conclusion of a department investigation. Another element of the Stephen Comninos Law is drug testing all persons applying to work or already working as a direct care staff for individuals with developmental disabilities. This includes community care residence providers and individuals working as volunteers. Employees at state-operated developmental centers are already subject to drug testing. Now, with the implementation of the Stephen Comninos Law, drug testing must be done for all persons applying to work or volunteer or already working or volunteering in community settings. The department is working to implement this element of the law, and more information will be provided in the near future. However, it is important that providers understand the elements of the Stephen Caminos Law as they relate to drug testing. These elements include that the test looks for the presence of controlled dangerous substances. Anyone who refuses to take the test or tests positive for a controlled dangerous substance will not be considered for employment. Per the law, all current employees of a program or living arrangement other than a developmental center are subject to random drug testing for controlled dangerous substances at least once per year. The Department of Human Services will cover the cost of drug testing. The law also allows employees to be drug tested if a supervisor suspects an employee is under the influence of drugs. It is the responsibility of the supervisor to look out for the safety of individuals with developmental disabilities. If at any time a supervisor observes an employee acting as if they are under the influence of a controlled dangerous substance, they must take appropriate action, and this action may include drug testing. If staff refuse to take a drug test, the individual's employment must be terminated. Under the law, at the discretion of the provider, staff who test positive for a controlled dangerous substance may be referred to treatment, or their employment may be terminated. Again, DHS facility staff are already subject to drug testing. This provision of the Stephen Caminos Law applies to community providers. Providers should begin to develop policies and procedures related to drug testing and ensure that staff is aware of them. It is important to work within your human resources or personnel office in situations where there are unique and special circumstances. Remember, you have a responsibility to help keep individuals healthy, protected, and safe from harm. The Department of Human Services is working to update regulations affected by the enactment of the Stephen Caminos Law. These regulations include the standards for community residences for individuals with developmental disabilities, the Manual of Standards for Community Care Residences, the standards for community residences for persons with head injuries, the Central Registry of Offenders Against Individuals with Developmental Disabilities. Additionally, the Department is amending Administrative Order 205, DDD Division Circulars, and other internal policies to comply with the Stephen Caminos Law. This information will be posted on the department's website as it becomes available. For licensed agencies or programs, the department's Office of Licensing will check for compliance with the elements of the Stephen Caminos Law during routine and unannounced site visits. For non-licensed community programs, the DDD, Provider Performance and Monitoring Unit, will check for compliance with the elements of the Stephen Caminos Law. Your facility, agency, or program plays a crucial role in ensuring the health, safety, and well-being of individuals with developmental disabilities. And the work you and your staff do every day matters. The individuals and their loved ones rely on you and your staff. You and your staff make a difference in the lives of the individuals you care for. When abuse, neglect, or exploitation occurs to an individual with a developmental disability, their physical and emotional health and their safety and well-being is affected. Facilities, agencies, and programs have a responsibility to keep individuals with developmental disabilities safe from harm and protected from abuse, neglect, and exploitation. Together, the Department, DDD, and all facilities, agencies, and programs have a shared responsibility to abide by all laws, regulations, and policies guiding our work with individuals with developmental disabilities. This includes the provisions within the Stephen Komnenos Law outlined in this presentation. To assist with the implementation of the Stephen Komnenos Law, the Office of Program Integrity and Accountability has set up an email account for providers to send questions. That email address is dhs-opia@dhs.state.nj.us. Thank you for the work you do every day to provide care and services to individuals with developmental disabilities.